My Lord Chief Justice and members of the court, first I want to thank my colleague for donating his time to me. And I want to introduce my team. I appear with the Solicitor General, Mr. J. Muturi, and Mr. Samuel Kaumba, who is sitting right here. My lords, I will be very brief. I have 3 thematic areas, and I will answer 5 questions. What are the thematic areas? The first one, I will address the issue of alleged irregularities during the poll held on the 26th of October. Secondly, I will address allegations made regarding the conduct of state officials during that poll. And finally, I will address your lordships on the theme of the law applicable in fresh presidential elections. Let me ask and try to answer my first question. Was nomination a procedural requirement following the order given by this honorable court post the last election? My lords, I want to start by observing, as most of my colleagues have done, and I think my job has been made so much easier in that I am speaking last, and all the issues I'm going to talk about have been at great length addressed by some mostly very competent advocates. So I will not repeat the very good arguments they have made. But I want to refresh the court's memory on how did we ever get the Supreme Court to pronounce itself on this question of what was a fresh election. Most members of the court were still in the court then. It is the Attorney General who came in and informed the court when we were confronted with the 2012 petition that there was a real possibility that even if the court were to rule in a certain way, the country would still be confronted with a dilemma as to how that election was to be conducted. I therefore framed, there was a flippant comment about the Attorney General being a perennial amicus. That is for failure to understand what the Constitution says. The Constitution actually requires the Attorney General to be a permanent amicus because he's the custodian, not personally, the office of the rule of law. The court gave very clear, very lucid, very detailed, very well thought out directions. They are contained in paragraphs 289, 290, 291, 292, 293, and 294. And I will not read because some of my colleagues have already read. And what the judges said, in my opinion, remained the ruling jurisprudence. It remained the ruling jurisprudence because this is the Supreme Court of Kenya. When it addresses a legal issue, when it pronounces itself on a legal issue, that becomes the prevailing jurisprudence until that issue is either litigated afresh before the Supreme Court or a decision is made by a lower court, distinguishing and probably expanding aspects not directly dealt with by the Supreme Court. In my very humble opinion, as at the date we left this court after your judgment, there was no doubt at all what the fresh election entailed. And I think that the chairman of IEBC has been so unfairly, in my view, criticized in how he organized the election because he was following to the letter the ruling jurisprudence of the day, which was the decision of the Supreme Court. Life would have been easier for him had the intervention of Dr. Ekuru Okot not been made. That intervention, which resulted in the judgment of Mativo J, then created a new dynamic, not necessarily a tension at all between the Supreme Court advisory opinion, as I understand it, and Mativo J's decision. The two could be could be read harmoniously as passively interpreting the Constitution, which is what the chairman of IEBC did. In my very, very humble view, therefore, my lords, the one issue that this court needs to appreciate is that the election of the 26th of October was conducted under the supervision of the court, because we conducted that election under the order of the court. And the order of the court is so clear. Do it within 60 days and do it strictly in a compliance with the Constitution and the law. That was the first order. The second order was the order of Mativo J, which was, there is no legitimate reason of failing to include the names of persons who had otherwise participated in the prior election. It is therefore the very humble submission of the Attorney of the Republic that IEBC conducted itself in accordance with the Constitution and the law. And that the advisory opinion of the Supreme...
Sorry, Mr.
Yes, my Lord. In due respect, I did not want to interject that in general. You taught me professional ethics and must be careful. But my Lord, I would seek your directions. So as far as I can recollect, his application as an amicus was not allowed. And if I recollect, the AG was allowed to come in as an interested party in petition number 4 to the extent of representing the state agencies. Where we are going, my Lord, I'm feeling that the AG has now become the advocate for IBC and the chairman.
As I was saying before, I was very rudely interrupted. An interested party has the same latitude as any other party and must be able to present to the court his own opinion about the issues in controversy. There are numerous issues in controversy. I don't want to comment about them. I have said I have only 5 questions. I have finished answering the first one, and I was about to move on. I would hope some protection from the court. We have been contemplating legislation to put some years of experience for appearing before this bar. There may be evidence to support that. Let me come to question number 2, and it is this. What was the applicable legal framework for the withdrawal of a presidential petition? Heavy weather has been made of the fact that a candidate was included in the election who had, many words have been used, who had withdrawn, abandoned, and several other words were used. I want to remind my lords and my ladies, with your permission, that again in the relevant advisory opinion we have alluded to, although the court did mention the issue of a party abandoning the quest to be in the subsequent election, at that particular time, and that has been spoken to by my colleagues, the court did not pronounce itself on when one would be deemed to have abandoned. And I think it wasn't necessary because it didn't arise in a material fashion. But I need to draw the court's attention, my lord, to the fact that Parliament actually intervened. Post-Raila 2013, Parliament intervened and clarified when a candidate would be deemed to have withdrawn. And my lords, if we look at the elections general regulations, this has been alluded to. 52 talks about withdrawal after nomination. Now, to my mind, I know there is a controversy of, can you only be deemed to withdraw if you use this procedure? My answer is yes. Where the law, and these courts have said that over and over and over again, where the law provides a procedure, that procedure must be complied with. And my lord, I think that if I may illustrate the absurdity of not having this procedure. If any of the candidates, rather, if the candidate who now claims to have withdrawn was actually elected with a majority of votes on the 26th of October, we would be having a different petition. And the petition would be saying the letter had no effect because Form 24 was not filled. And it would be a very difficult case to face. It would be a very difficult case to face. So our submission here is that Form 24 is an important form intended to be used in the manner that it ought to be used. So does the alleged withdrawal of a candidate in a manner, in a procedure not known to law affect the subsequent election? The answer is no. It can't. It can't. At all. Indeed, nobody has been able to demonstrate throughout the 2 days we've been here, where is the injury? Where is the harm? Who is complaining? The candidate is not in this court complaining that they are in a ballot they didn't want to be in. The candidate has been consistent. By my letter, I achieved what I wanted. I have gone. I am doing other things. So who is complaining now before this court? And on whose behalf? There was never an effective withdrawal by any candidate under the law. IEBC did the correct thing. And my lords, I want to remind you this with your permission. I can speak from the bar that I have spent the last 1.5 years in court with all these parties, somewhere in different hats, but most of them not changing their colors very much. And we have had 2 themes. No, we've had 3 themes. IEBC must go. And we fought that for several months over several cases, that they had bungled a previous election, they had to leave. We went to another theme. IEBC is not ready, and the contracting for the supply of materials has been corrupt. We went through another round of numerous cases in the High Court, in the Court of Appeal, back to the High Court, and then we came back to another one that said the election in August cannot be held. I want to invite your lordships to take all this evidence together and be able to tell that the judicial process has been converted into another political battleground. That is something the court must resist. Because, in fact, IEBC, if it had anything to do with me, would have to be awarded a medal. At some point, they were publishing the material they needed 3 days, 4 days to the election, because we had been held up in court litigating whether the tenderer is black or blue or yellow or whatever, and so on and so forth. That environment had been made very difficult indeed. And therefore, it is my very humble submission and that the inclusion of Jirongo, Honorable Jirongo, the inclusion of Honorable Raila, all these were non-material issues. Nobody has demonstrated that anything in this election turned on that point. Nobody has come to say, my vote was not counted because Jirongo was on the ballot. Or nobody has come to say, the person who was finally elected, some of his votes were taken by candidates who should have been. We have no such arguments. So they are non-issues and we should leave them out. I come to my third question. I'm beginning to wonder whether I'll need all the time. What was the legal effect of the failure to hold an election in 25 constituencies? What was the legal effect, if any? None. Simple answer, none. Why? Because this constitution does not require majorities based on constituencies. It requires majorities based on counties. Had the drafters of the constitution intended to make every constituency part of the majority that elects the president, it would have done so. There is no inconsistencies, my lords, I urge you, between the Constitution saying there shall be an election in each constituency. What does that mean? Every effort must be made to ensure that any person who wants to vote in any constituency in Kenya is afforded the opportunity to do so. So what is the burden on IEBC? Is to make good faith measures. IEBC must make good faith measures to prepare every constituency for an election. It must register voters, it must recruit election officials, it must prepare the necessary ballots and materials, it must engage the political parties, etc., etc., etc. After that, what is to happen? IEBC is to make every effort to open the polling station and to facilitate voters to do so. Two things can happen. A voter may voluntarily say, I have seen your polling station, I am not in the business of voting, it is against my religion. What is IEBC to do? IEBC is to make a return only, a return that says, I seem to have offended somebody. IEBC, my lords, has only one duty, to make a return and to say, at Dumberi Primary School, voting station, whatever, we opened at 6 a.m. Nobody came to vote. That's one option. The second option is for IEBC to make every effort to get to the voting area and to be repulsed by demonstrators, conscientious objectors, all manner of persons who, in their own estimation, feel an election should not be held. What is IEBC to do? It can only make a return, saying, we were not able to hold the election today, so we will try to hold it on another day. That is exactly what happened in this particular situation. Save for this, my lords, and I think we should remind ourselves about this. The 60-day deadline was ticking away. And if I have your permission, I'll go back for 1 second. The reason why the August 8th election was under such great siege, politically and legally, is because had the election not been held on the 8th, an argument was already being developed that any government in office after the 8th without an election would be illegitimate. No, I'm back to 8th. I'm back to 8th, I'm coming to 26th. The danger on the 8th was this one. Had those who had gone to court to say the tender was compromised, had the ballots not been printed on time, had the ballot not been brought on time, had the preparations by IEBC been so compromised that there was no election on the 8th, the argument was that post the 8th, there was no constitutional government in Kenya. And therefore, I had this argument made many times, especially among a group that even your lordships may have become familiar with. They seem to practice mostly in television stations early in the morning. And they seem to be very convinced about their knowledge of constitutional law. I have my own doubts. I am very alarmed, and I know there are lawyers here senior to myself in learning. I'm very alarmed, my lord, whenever a lawyer starts a sentence by, the law is absolutely clear. It must mean that the law school he attended. But I digress, my lords. Let me come back to this point.
That's what all of them say.
Yes. That's because they never come here and will never come here. My lords, so the election of the 8th was hostage to those legal and political forces. When your lordships exercised your discretion and we went to the second election on the 26th, the same problem arose. Now, discrediting IEBC became an alternative to complying with the court order. So IEBC is racing with a 60-day deadline. And as was demonstrated by my colleagues, 20 days had already been taken by the court, and I support the court in that you made a judgment that required to be fleshed out so that the parties could be adequately guided. So it became, therefore, necessary for IEBC to remain within the timelines, because if they did not conduct the election within 60 days, this constitution contains absolutely no remedy. I heard somebody yesterday suggest they should have come back to the Supreme Court. What would the Supreme Court do? I do not believe the Supreme Court can expand time. The Supreme Court cannot say, oh, you didn't do it within 60 days. Oh, that's very unfortunate. How much time do you need? Another 60 days, take it. And maybe when we post these problems that we are resolving, when we revisit some of the issues within the Constitution, these are some of the areas that we may want to think together and find a solution. So it is my very humble view that the chairman called the election in the way he did, and he was firmly within the law. I think my colleagues have already talked about Section 55B of the Election Act, and what the chairman did was defensible. Had he not done that, we would have plunged into the second constitutional crisis that has threatened our nation this year. So when the return that he did was correct. I got to my fourth question. Was the election free from violence, intimidation, improper influence, or corruption? Again, I think that has been addressed by my colleagues very well, except to say this, my lords, with respect and with your permission. One of the difficulties we have, people like myself, whose business it is to come before your lordships every day to defend the Republic of Kenya. We are litigating with a new crop of litigators who do not recognize civil procedure. They don't recognize the Evidence Act. They don't recognize any procedural legislation. What the old professors used to call adjectival law. It has been thrown out of the window. When we come to litigate now, the Constitution is flashed in our faces, and we are informed that the Constitution is absolutely clear. There is a right to vote, etc., etc. Nobody says the right to vote is not for minors. For example, it's a question of interpretation. Who is a minor under Kenyan law? We've started interpreting, so it's not clear. The Constitution is not clear. We have to interpret it. That's your job, my lords, and I must say that in my very humble view, the burden of proof has not been appreciated in these petitions. They say, we have a litany of complaints. There were policemen in a certain place, then there were protesters, and then there was a commotion, and that's bad. And then what else happened? And then there was a vehicle, it hit a pedestrian. I would have thought that's a traffic offense to be treated as such by the police. They say that's an election offense. And all these are now paraded. They are now paraded as evidence of no affidavit sworn by any person. I was in a certain place, this happened, nothing. An allegation, a bare allegation, becomes the basis. In 2013, my lords, you looked at this problem of proof, and you said proof is fundamental. The Supreme Court is a judicial body. It is a judicial body. The complaints being made to it must be complaints that can withstand the test of our evidence law. The law of evidence is important. So no litany of complaints can dispose the burden of proof, nor the standard of proof. And my lords, I don't want to read because you have but I do quote from the 2013 decision where you, as you know already, my lords, I am myself one of those who consider that 2013 decision to have been quite sound. And there are many, many parts of that decision that I have found very useful in other litigation that I have done in other courts. But let me also bring your attention, my lords, to let us take one issue where, for example, the parties are complaining about. There is a question of whether state officers can engage in politics or can advertise government achievements. This matter, for those who read your judgment 2017, you dealt with it. And you dealt with it, in my very humble view, very well. What guidance did you give us? You told us, please stop raising before these courts matters that you already know are making their way up from the High Court to the Court of Appeal. We will not assume jurisdiction to bypass that process. One would have thought that before filing a fresh petition, one would read how the old one was determined. That hasn't happened in this petition. Now, so I don't want even to go into, supposing you found a few incidences of of what is complained of did exist. Again, unfortunately, you will still have to go back to what is the standard, what is the proof, what you need. It must be systematic, it must be widespread, it must be intended, and that the existence of those facts must be proved beyond reasonable doubt. Not by my friend Mr. Mr. Dombi. It's not for Mr. Dombi to speak from the bar. It is for witnesses who claim to have been so affected to do so. There's one question that I would like my lords to ask yourself. If it is alleged that there was violence during these elections, let us start with the question: who instigated this violence? It has not been suggested by anybody that the government of the Republic of Kenya unlocked its police centers to go into villages and towns to ensure that people didn't vote by spreading violence. In fact, what has been shown by the evidence available is that the opposite happened. The government of the Republic of Kenya, and I can say this, it is in Dr. Matiangi's affidavit, not only it brought out every possible security officers, including prison wardens. They were removed from the prison to go and ensure that those who wanted to vote could vote. And therefore, the allegation that there is violence from which you are meant to extrapolate that it is the government that instigated the violence to ensure that people didn't vote is turning truth on its head. And it is manifestly untrue. And my Mr. John Jomoe, at least he's going to headline his own petition now. Mr. John Jomoe, in his affidavit, paragraph 10, paragraph 11, 12, 13, 14, 18, 19, Nasanga Aki's affidavit, paragraph 4, 8, 12, 17, 19, and 21. This is what constitutes the entire allegations, set of evidence by the petitioners. Please, my lords, when you have time to look at this, do consider it, and you will see that there is no iota of support for that. Finally, I want to come to this point because my time is almost over. Section 83. This is a red herring. Section 83 is a non-issue at this point in time. The law is in force. It is the subject matter of litigation in the High Court. That litigation is making its way up. Let me go to what is my real final point, and it is this. Principles matter. When we read this Constitution, my lords, the Constitution matters. And you must, as much as is practically possible, give effect to the Constitution. But my lords, outcomes matter. Outcomes matter. And that is why in our jurisprudence, for the longest time, the court has been able to say, we find, say in defamation, we find that Senior Counsel Ahmed Nasir said of his colleague Githu Muigai this, and it is defamatory. But we only give 50 cents in damages. The court has been, the common law recognizes that there can be an injury that does not require a remedy that is out of proportion. So outcomes matter. My lords, from everything that is here in front of you, there is no reason, no evidence, no law that has been placed before you that would allow you to upset the repeat election. If we were to do that, and this is my last prayer to the court as one of your advocates, we must be careful about outcomes. If we were to nullify an election such as this one on the basis such as those that have been given, we will be rewarding the people sabotaging the Constitution. So what do you require to do? It is to ensure that the election is not held. That's all you need to do. And you can do it enough times as to ensure that a real constitutional crisis has been precipitated. So you make sure that on the 8th of every 5 years, no election is held, because either you have abducted the chairman of IEBC, or you have burnt down the National Tallying Center, so we should not reward individuals sabotaging the Constitution. We must allow the Constitution to continue to function for the majority of those who want to obey it, and above all else, who want to obey the order of the court. We would have no answer to the millions of people who lined up on the 26th if we told them, we have invalidated your election because the name of a person who didn't want to be in the ballot was on the ballot, or because police went to put down the riot in a place where the people were claiming they don't want to vote. And that person would say, what about me? I wanted to vote. I woke up early. I went to the voting center and I voted. When will you tell me whether my vote counts? We have to respect the rights of all Kenyans. Those who voluntarily say in Kenya, I do not want to vote. There is no constitutional requirement to vote. That is their right. But those who go out and vote must have their vote counted, and they must have a decision made by the Electoral Commission and finally by you, my lords. I thank you very much. And if my lords have any supplementary question, I'll be happy to answer.